All right, listeners, buckle up because today we're taking a deep dive into a topic that's both crucial and a little bit under the radar, secured transactions. We're going to unravel the world of loans, collateral, and what happens when things go south.
You're absolutely right. It can feel like a hidden world, but it's one that touches our lives more often than we might realize. Think about it. Every time someone finances a car or a business takes out a loan, chances are there's a secured transaction at play behind the scenes.
Okay, so before we get too far down the road, let's start with the basics. Can you give us a simple explanation of what a secured transaction actually is?
Sure, imagine you're looking to buy a car but don't have all the cash up front. You head to a lender, and they agree to give you the money. But they want some kind of guarantee that they'll get paid back.
Right.
That's where collateral comes in. They'll use your new car as security for the loan. So that's essentially a secured transaction in action.
So if you stop making those payments, the lender can just come and repossess the car.
Exactly. They have a legal right to take possession of the collateral if the borrower, defaults on the loan. But there's a whole legal framework that governs these transactions with two main stages we need to understand: attachment and perfection.
Attachment and perfection, those sound a little intimidating. What exactly are we attaching and perfecting here?
Think of it this way. Attachment is about establishing the lender's rights to the collateral, while perfection is more about securing their position against other potential creditors who might have a claim on that same collateral. It's like a two-step process to make sure the lender's interests are protected.
Okay, let's unpack attachment first. What exactly needs to happen for a security interest to attach to the collateral?
There are three key ingredients: agreement, value, and the debtor's rights in the collateral.
Okay, agreement seems pretty straightforward. There needs to be some kind of contract, right?
You got it. The lender and borrower need to agree that the lender has a security interest in the specific collateral. This agreement is usually in writing, which is the most common scenario, but it can also be oral in certain cases, like when the lender takes possession of the collateral right away, like we see with pawn shops.
So you walk in with your, let's say, grandma's necklace, they hand you the cash, and bam, secured transaction.
Precisely. And that brings us to the second element, value. The lender has to give something of value to the borrower, typically a loan, in exchange for that security interest.
Makes sense. No money, no security interest. And of course, the borrower has to actually own or have rights to the collateral they're putting up. But what about those buy now, pay later deals? Does ownership really come into play there?
That's a great question, and it can get a bit tricky. Sometimes, with those deals, the lender might actually retain ownership of the goods until you've made all the payments. But even if you technically own the items, they can still use them as collateral and repossess if you default.
Wow, so even when you think you own something outright, there might be strings attached. That's something to keep in mind for sure.
Absolutely. And it highlights why it's so important to really understand the terms of any financing agreement before you sign on that dotted line.
Okay, so we've got agreement, value, and the debtor's rights. Anything else we need to know about attachment?
Well, there's one more twist that can be a little confusing: the after-acquired property clause.
After acquired property? What in the world is that?
This is where things get a little interesting and potentially risky for borrowers. An after-acquired property clause allows the lender to claim not only the assets the borrower currently owns, but also anything they acquire after the agreement is made.
Hold on. You mean if I take out a loan and use my current equipment as collateral, the lender could have a claim on any new equipment I buy in the future, even if it's totally unrelated to the original loan?
You got it. It might seem a bit unfair, but from the lender's perspective, it's a way to protect their investment. Let's say you're starting a business and use your existing equipment as collateral. If you then go and buy a bunch of shiny new equipment, the lender wants to ensure their security interest covers those assets as well.
I can see how that would benefit the lender, but from the borrower's side, it feels like you're constantly playing catch-up, like your future purchases are tied to a past loan.
You've hit on a key point. These clauses can create a kind of ongoing obligation for the borrower. It's really crucial to be aware of them and understand the potential long-term implications before signing any agreement.
Okay, so attachment is all about the lender securing their rights against the borrower, and it can even extend to future assets. What about the lender's responsibilities? Do they have any obligations once the security interest is attached?
Absolutely. The lender isn't just free to do whatever they want with the collateral. Even before the loan is fully repaid, they have certain duties. For example, they have to provide a termination statement once the debt is paid off. They need to confirm the outstanding balance if the borrower requests it, and they're obligated to take reasonable care of any collateral that's in their possession.
So it's a two-way street with rights and responsibilities on both sides. But we've really only scratched the surface of this secured transactions world. What about this perfection stage you mentioned?
That's where we move from lender versus borrower to lender versus other potential creditors. It's all about establishing priority and making sure the lender has the upper hand if things go wrong.
So there could be multiple lenders with claims on the same collateral.
Exactly. And that's where perfection comes into play. It's a way for lenders to secure their position in line, ensuring they get paid first if the borrower defaults.
So it's like a race to the finish line. First to perfect wins.
You could say that. And there are actually several different ways to achieve perfection, each with its own advantages and disadvantages.
Well, I'm definitely hooked. We'll have to delve into those perfection methods in our next segment.
Indeed. We'll uncover the different strategies lenders use to secure their claims and explore what happens when those claims collide. Stay tuned.
We'll be right back.
Welcome back, deep divers. Ready to jump back into the world of perfection methods.
Absolutely. Last time we left off with this cliffhanger about multiple lenders potentially having claims on the same collateral. It sounded a little bit like a recipe for disaster.
It definitely can be, especially if those lenders haven't taken steps to protect themselves. That's why perfection is so important. It's like a safeguard that helps establish who has priority among all those competing claims.
So it's not just about the lender and the borrower anymore. We're talking about the lender and all these other potential creditors out there.
Exactly. It's like a strategic game, with each lender trying to position themselves for the best possible outcome. And that perfection date becomes a key piece of the puzzle. The earlier you perfect, the stronger your claim.
Okay, so let's break down these perfection methods. You mentioned there are several different ways to go about it.
There are 5 main methods: filing, possession, control, automatic perfection, and temporary perfection. Each one has its own quirks and is better suited for different situations.
Let's start with filing, since you said it's the most common. What exactly does that involve?
Filing is all about making your security interest public knowledge. It's basically like putting up a big sign that says, "Hey everyone, I have a claim on this asset." The lender files a document, called a financing statement, with the appropriate government office, usually at the state level. This basically puts everyone on notice that they have a security interest in that particular collateral.
Does it have to be some super formal, legalese-filled document?
Not really. The main thing is that it needs to contain enough information to alert other potential creditors. Things like the names and addresses of the debtor and creditor, a description of what the collateral is, and the debtor's authorization.
So it's more about transparency than technicalities, just letting everyone know you're calling dibs.
Exactly. And it's important to remember that the type of financing statement you use can actually vary depending on what the collateral is. For most business assets, there's a standard form called a UCC-1. But for things like cars or farm equipment, there are specialized forms tailored to those specific types of assets.
Got it. Different assets, different forms. So filing is like establishing your claim on the public record. What about this possession method? That one sounds pretty straightforward.
It is. If the lender takes physical possession of the collateral, they've automatically perfected their security interest. It's the most secure method because they literally have the goods.
Like those pawn shop examples we talked about earlier.
Yeah.
You hand over the necklace, they give you the cash, the pawnbroker has a perfected security interest, right?
You got it. Possession is simple, effective, but it only works for things you can physically hold. But what about intangible assets? Things like investments or intellectual property?
That's where control comes in, right? Like possession, but for things you can't touch.
Exactly. Control means the lender has the legal right to dispose of the collateral without needing the borrower to do anything else. So, for instance, if you were to use stocks as collateral for a loan, the lender might require you to sign something giving them control over your brokerage account. That way, if you default, they can just sell those stocks without needing your permission.
So control gives the lender the power to act quickly if the borrower fails to repay. Makes sense, but it also seems like it could be risky for the borrower, you know? It's like handing over the keys to your valuable assets.
You're right. It is the delicate balance. It's really crucial for borrowers to understand what it means to give a lender control over their assets.
Okay, so we've got filing, possession, and control. What about this automatic perfection? Does that mean you literally don't have to do anything?
It almost sounds too good to be true, right? But there are certain situations where perfection happens automatically without any extra steps from the lender. The most common example is what's called a purchase money security interest, or PMSI. in consumer goods.
PMSI, that's a mouthful. Can you break that down a bit?
Imagine you're buying a brand new fridge and you're financing it through the store. That store is providing the loan that lets you buy the fridge. That's a PMSI. The loan is specifically to purchase the collateral. And since it's for a personal use item, the security interest perfects automatically.
So because the loan is directly for buying the collateral, it gets special treatment.
Right. But it's important to remember that this automatic perfection only applies in those very specific PMSI situations involving consumer goods. If it were a business loan for, say, a commercial refrigerator, the lender would have to file a financing statement.
Okay, so automatic perfection streamlines things for consumers in certain cases, but you also mentioned temporary perfection. When does that come into play?
Temporary perfection basically provides a safety net in two main scenarios: when collateral is sold and when a borrower moves to another state.
Okay, let's say I sell my car, but it's still being financed. What happens to the lender's security interest? Does it just disappear?
Not exactly. The lender actually gets a temporary perfected security interest in the proceeds from that sale. It gives them time to adjust things, like the security agreement, or file a new financing statement to keep their priority.
So it's kind of like a bridge, making sure the lender's rights aren't just left hanging during the transition.
Precisely. And it works in a similar way when a borrower moves to a new state. The lender gets this 4-month grace period to re-perfect their interest in that new location. This makes sure their claim isn't messed up just because the borrower moved.
Makes sense. You wouldn't want a simple move to undermine the whole secured transaction. Okay, so we've covered all 5 perfection methods: filing, possession, control, automatic, and temporary. My head's spinning a bit, but I think I'm starting to grasp the big picture.
It is a lot to digest. But getting a handle on these methods is crucial, especially for lenders. Choosing the right approach is vital to protect their interests.
But what about the borrower? Where do they stand in all this? What happens if they can't keep up with their loan payments, if they default?
It's a really important question, and it takes us to the heart of what makes secured transactions so powerful. When a borrower defaults, the lender has some pretty serious tools at their disposal to try to recover their losses.
Like repossessing the car.
That's certainly one option, but it's not always the first or even the best one. We should probably explore the different paths that can unfold when things go sideways in a secured transaction. It can get a bit intense, but it's definitely worth understanding the potential consequences.
Well, I'm ready to dive in. Let's see what happens when things get real in the secured transaction world. Welcome back, deep divers. We're at the final stage of our journey into secured transactions. We've covered how these agreements work, how lenders safeguard themselves against other creditors, but now we're going to explore what happens when borrowers can't hold up their end of the bargain.
That's right. This is where things can get a bit more serious, and understanding the consequences is really important for both sides, lenders and borrowers.
So let's set the scene. We have a borrower who's missed some payments, maybe because of a job loss or some unexpected expenses. What happens next?
Well, the first thing to understand is that the lender's main goal at this point is to recover their money. And because of that security interest they've established, they have a few options.
Like repossessing the car?
That's often what people think of, and it's certainly one tool in the lender's toolbox. But it's not always the first or best approach.
Really? I thought repossession was like the go-to move when someone defaults.
It can be, especially for collateral that's easy to repossess, like a car. But lenders also have to consider the costs involved. Repossession can get expensive, and there's always a risk that the collateral might be damaged or even missing.
So what other options are there?
One alternative is to try to work with the borrower and restructure the loan. This could mean changing the payment terms, extending the loan period, or even, temporarily suspending payments.
So instead of these drastic measures, they try to find a solution that works for both sides.
Exactly. It's often in everyone's best interest to keep the borrower in good standing, as long as there's a realistic chance of repayment.
That makes sense. But let's say those efforts don't work out and the borrower keeps defaulting. What then?
If those friendly solutions are off the table, the lender has a couple of paths they can take: self-help repossession or judicial action.
Self-help repossession, that sounds a little Wild West.
It might sound that way, but there are legal guidelines for this process. Basically, it means the lender can take possession of the collateral without going to court, as long as they don't breach the peace.
Breach the peace? What does that even mean?
It means they can't use force, threats, or any kind of violence to repossess the collateral. They can't break into someone's home or cause a public disturbance. It has to be done peacefully and discreetly.
So no late-night car chases or breaking down doors?
Not if they want to stay on the right side of the law. If the collateral is out in the open, like a car parked on the street, they can usually take it without much hassle. But if it's inside a locked garage or a house, they'd need a court order.
So there are some limits to their self-help powers. What about this judicial action then? What does that look like?
Judicial action means going to court and getting a judgment against the borrower for the amount they owe. This basically gives the lender the authority to seize assets, garnish wages, or even put liens on property to satisfy the debt.
So that's bringing in the legal big guns.
You can say that.
Yeah.
It's more formal, more controlled, but can also take longer and cost the lender more.
So they have to weigh the pros and cons, the potential costs versus how likely they are to actually recover the debt.
Exactly. The best choice often depends on the specific situation, the type of collateral we're talking about, and the borrower's overall financial picture.
Okay, let's say the lender has successfully repossessed the collateral. What happens to it?
Usually they'll sell it to recover their losses. But there are rules here too. The sale has to be commercially reasonable. They can't just sell it for a ridiculously low price to a friend or family member.
So no shady deals going on.
Right. The goal is to get a fair price for the collateral. And the money from the sale goes first to cover the debt, any expenses, and then if there's anything left over, that surplus goes back to the borrower.
So even in a default situation, there's a chance the borrower could get some money back.
It's possible, but it depends on what the collateral sells for and how much is still owed.
What about the borrower's rights in this whole process? Do they have any options?
Absolutely. They have a right of redemption. This means they can get the collateral back before it's sold if they pay off the entire debt plus any expenses. It's a chance to fix things and not lose the asset.
So there's a window of opportunity to step in and save the day, but what if they can't come up with the whole amount? Are they just out of luck?
Not necessarily. Sometimes they might be able to work out a payment plan with the lender, or maybe work with a credit counseling agency to look at other possibilities.
So even when it seems like things are going really bad, there might be ways to salvage the situation.
That's right. Communication is key. It's always better to reach out to the lender and see if you can work something out than to just ignore the problem and hope it goes away.
That's good advice for anyone who's dealing with money trouble.
As a one more point I want to bring up, especially for consumer goods, it's called the 60% rule.
The 60% rule.
Yeah, this rule is an extra layer of protection for consumers. If the borrower has already paid off at least 60% of the debt on a consumer good, the lender can't just keep the repossessed item. They have to sell it within 90 days, unless the borrower agrees to let them keep it.
So even if you've defaulted, you still have some rights to the collateral if you've paid off a good chunk of the loan.
That's right. It's there to prevent lenders from taking advantage of consumers who have made a substantial amount of payments.
Well, this has been a real deep dive into the world of secured transactions. We've gone from the initial agreement through the different strategies for perfection to what happens when things don't go as planned.
It's definitely a lot to take in, but hopefully our listeners have a better understanding now of this sometimes hidden world that impacts so many financial dealings.
For sure, knowledge is power. And understanding how secured transactions work can help everyone make better decisions, protect themselves, and navigate the financial world with more confidence.
Whether you're a lender trying to secure an investment or a borrower trying to understand your rights, this knowledge can help you make smarter choices.
Thanks for joining us on this deep dive into secured transactions. Until next time, keep exploring, keep learning, and keep diving deep.